Thank you for joining us here for this special interview at the National Communications Network. My name is Shaquan Gill, and I'm joined by Special Prosecutor Darshan Ramdhani K.C. Mr. Ramdhani, thank you so much for joining us.
Thank you, Mr. Gill. I'm glad to be here.
Yes. So let's talk about some of the cases that are currently before the courts in relation to the March 2, 2020 general and regional elections, some election-related cases. Can you give us a backdrop as it relates to where these cases came from and what these cases are about?
Thank you for that. It's important that I put context to it as you're asking me. As we all know, and you would have seen quite a lot of things played out during the March elections of the 2020 general and regional elections. And you would have seen, as I saw when I was sitting in Grenada, much of the activities played out on social media as well. And following the declaration, the DPP's office, the police department, I think, conducted investigations. There were private criminal charges laid sometime around September or October of 2020, if you can recall. And the DPP's office intervened and withdrew those charges and laid a number of charges against 9 persons, including Mr. Lowenfield and Mr. Mingo. And those 27 charges which were laid in a staggered way. And because they were laid incrementally, because the investigation was a huge investigation, involving, presently we have nearly 90 witnesses.
Wow.
And so the investigation was a huge investigation, and so charges were being laid as the evidence unfolded for the police to gather and collect. And so those charges came before the chief magistrate. Some were transferred to Magistrates Isaacs, and 2 of them were transferred to Magistrate Daly initially. This took place around between October and December of 2020. I was not involved in the matter at that time. There were a number of other prosecutors involved in the matter, many of whom are still in the matter, and I lead them. And so the prosecutors were between court dealing with the initial steps of these charges. I believe there were about 9 charges, or just over that, before Magistrate Isaac. Majority of the balance was before Chief Magistrate. And because these charges were indictable summary charges, in the sense a hybrid charge, the first thing that happens in the magistrate's court is to determine how these charges are going to be tried. Right. The fundamental underlying charge was conspiracy to defraud an elections.
Okay.
And so even before I stepped into the matter, and I came in around March, April of 2021, even before I came into the matter, each of these magistrates had to determine how these matters were going to be tried. And the question was, do we try them summarily? In other words, the magistrate herself try the matter and make a determination as to guilt or innocence, or do they conduct a preliminary inquiry and find whether or not there's a prima facie case? And if there's a prima facie case, then there's a committal to stand trial in the High Court, and you're tried by a jury. Yes? And so both sides, I think the defense team, by and large, in each of these matters, there are a number of lawyers involved in defending these defendants. All of them made requests for the matters to be dealt with by way of a preliminary inquiry and to be sent to the High Court if there was a committal to be tried by a jury. Of course, I believe they're all hoping that there would be a discharge and there would be no committal, and then they'd be free to go. But that process would have involved a considerable amount of time being spent in the magistrate's court as a preliminary inquiry. And if there was a committal, then another considerable amount of time would be spent in the High Court as a trial. And at that point in time, the prosecution considered that these matters, and we still consider that, should be matters which should be dealt with expeditiously, because the nature of the matters themselves, they came out of a period of anxiety in Guyana, and the trial of these matters are going to renew those anxieties, and public attention when these trials begin is going to be focused on these matters. And you can tell the kind of discussions in the national forum, what will be those discussions. And so the prosecutors have always wanted these matters to be dealt with expeditiously, and they made applications to each of the magistrates for the matters to be tried summarily. There, in my view, looking back now, very early, I believe one of the magistrates, Magistrate Daly, acted quickly and made a determination around January, I believe, or February
Of what year?
2021.
2021, okay.
Yes, very next year. And determined that the several charges that were before her should be tried indictably. In other words, there should be a preliminary inquiry, and the matter should go to the High Court to be tried by a jury if there was a committal. She considered that it was a serious matter, and that it should be tried by a jury of peers. The prosecutors, of course, wanted a professional judicial officer to try the matters and not have Guyanese sit and judge matters like this. Because you can, I'll come back to that. So around very early into 2021, Magistrate Daly made that decision. The prosecutors have appealed that, and it's gone to the High Court, and a judge has ruled that the magistrate has acted properly, and Justice Holder did. And after he did that, there was a further appeal. It was a judicial review application first, forgive me. And then that judicial review application was considered by Justice Holder, who said that he believed that the magistrate acted properly. Arguments were made before him that these offenses carried a maximum of 1 year each, maximum sentence of 1 year. And when you have offenses which carry a maximum of 1 year, they should really be tried by a summary court. Nowhere has they, in my experience, and if I'm wrong, I can be shown to be, but in my experience, no magistrate has ever sent to the High Court a matter where the maximum penalty is 1 year. In fairness to Magistrate Daly, I believe that there was some discussions at the time that the sentence was life imprisonment. But that has since been clarified, and that was clarified to Justice Holder. But he felt that since these arguments were not made before Magistrate Daly, that she did what she should do. So the matter is under appeal, but those are those two matters. The other matters, before court number 3, Magistrates Court number 3, the same question arose, whether the matter should be tried summarily or whether it should go through that extended period of a PI, a preliminary inquiry, and then a High Court trial if there's a committal. And the defense team again raised, and they now raised, that since one magistrate had sent it to be tried indictably, then Magistrate Isaac should follow. By that time, I had commented the matter. And I believe I sought to clarify for the court that, look, we're not dealing with cases where the maximum penalty that you can impose is life imprisonment. The maximum penalty that you can impose for these charges is 1 year imprisonment. That's what the law says if you're found guilty. And we considered that election cases are not cases, and I made these submissions, are not cases where you should have 12 Guyanese sitting trying them. Having regard to the nature of politics in Guyana.
Yeah, and I was going to ask that question. Why not?
Because of the, you think it through. Guyana's politics is, in a sense, you have two major political parties. And these two major political parties are, you've seen the votes cast, you have supporters on both sides. Yes? And when you pick a jury, you're going to be picking a jury from Guyanese, of your peers. And you're likely to have people who support either side. And the political climate of Guyana at that time, and I think perhaps a little bit now, I don't know too much about politics, but from a layman perspective of that, one can understand a prosecutor saying that, look, don't put Guyanese, ordinary average Guyanese to sit and judge cases like this. You're going to cause them to have anxiety depending on the level of support and loyalty they have. Yes? But put that argument to the side. Let's not even consider that. the singular factor that these charges carry a maximum of 1 year. Magistrates on a daily basis, if you, Mr. Gill, go and sit in the magistrate's court for half an hour every day, for a week, 1 week, you will see as a matter of routine, charges will come before the court. The maximum penalty is 15 years imprisonment. And the magistrate will routinely take those matters, all magistrates, and transform them into summary processes and try them summarily, where the maximum penalty they can impose, quite apart from these offenses which carry a stated and expressed maximum penalty of 1 year. When the magistrate breaks down a charge from indictable, the magistrate's maximum penalty is 3 years imprisonment, generally. And on a daily basis, as a matter of routine, criminal procedures in the criminal courts, indictable offenses which carry sometimes 10, 15 years are broken down into the summary process, and the magistrate will try them. You know, robbery is being tried, and robbery carries a bit more than many offenses. And unlawful wounding, grievous harm, these offenses are tried by magistrates on a daily basis. And so, where we were faced with a charge where charges the maximum was 1 year, we made the application. I made applications before court number 3, and I made similar applications before the chief magistrate. I'll come to that shortly. And Magistrate Isaacs took the position that she felt that some of those charges that were before daily, well, coming out of the general elections, having a political connection to the elections, or a connection to the election, put it that way, that similar charges were before her, so she should really await what the High Court and the Court of Appeal was going to say. On that particular note, we made one particular submission, that these matters were being tried before you, regardless of what was considered by the other court, and regardless of where that process was going to go, because you know we go to the CCJ.
Yes.
And so appeals don't stop until you get to the CCJ, and depending on the time spent. And I will tell you, the appeal has not yet been heard. So we're still waiting for those things that started in around January to February of 2021.
Yeah.
And we are now in 2023. I believe this is what?
September.
So we made submissions that your ladyship had an independent jurisdiction to exercise. You're exercising it on a daily basis in all kinds of matter. Let us consider the factors here, the kind of offense, maximum penalty that can be imposed, the saving of time, the fact that we'll have to lead 90 witnesses and a truckload of evidence here, and if you take the route of indictable charges, we'll have to lead it again in another court.
Yeah.
And then you will have the country looking on at this throughout all this time.
Maybe for years.
Please try it here. So the learned magistrate declined and said, no, she would await the outcome. And of course, we went through 2021. We came up before that court on many occasions to report the appeal had not yet been heard. Still awaiting it. We went through 2022 with that position taking place, and those charges were literally... So when I'd come into the matter, we had started to be preparing ourselves for trial. Yes? Speaking to witnesses and so on. And very early into the matter, the chief magistrate, with the number of charges before the chief, was asked to determine the same question. And the chief magistrate listened to submission and determined that those charges would be tried summarily before the chief magistrate. The same kinds of charges. Some of the persons were similar, say the same person. And the chief magistrate decided that she would try them summarily, but we will speak about what happened there shortly.
Yeah.
Yes? But that took place very early in 2021. So the chief magistrate had determined summary trial, and another magistrate was waiting. So in 2021, when I joined the prosecution team, one of the important things we have to prove in these charges is that a false declaration had been made. Yes? We have charged conspiracy,
Right.
yes, to defraud the electors of Guyana of the true result of the March 2020 elections. And to prove that there is a false declaration made from an evidential criminal law standpoint, it is necessary that we place before the court what we say is the true results of the election. And how do you get that? You get that, the evidence that we saw in 2020 and 2021 that we would have to lead would be statement of polls. Now, you'd recall that at that time, Mr. Lowenfield was still working with GECOM. So requests for statement of polls, when the police got into the matter, requests were made for statement of polls so that the police could gather these and make it part of the evidence that we would disclose. So when I came into the matter in 2021 early, I realized at that stage that these statement of polls were the most elusive thing apparently on the face of the earth. And what the prosecution and the police were doing at that time was seeking the assistance of polling agents sitting at every polling station in Region 4, which was the problematic
Yes.
district in terms of the results. That meant some 700 persons had to be interviewed, and statement of polls that they collected at the day of the election, signed by the polling officer. Those statement of polls had to be collected. So when I came into the matter, I think several hundred witnesses had already been interviewed. And those statement of polls were in the process of being collated. And the other set of hundreds, about 700 in total, steps were being taken to get this evidence. It wasn't the best evidence in the sense that it wasn't coming from GECOM, it was coming from polling agents. But you would see the signature of all the polling officers and everybody who was present. So the prosecution felt that this was necessary to prove this case. When I came into the matter, I thought that to lead 700 witnesses in a case would be alarming, quite apart from the 90 that we have and we will have. To have 700 witnesses with all these documents would take us years in the court. So what we did, we decided that we would go to the High Court, because if you recall, there was a civil ongoing proceedings ongoing in the court, that had been in the courts before the Chief Justice, and the statement of polls that were kept and the statement of recounts that were kept by GECOM, they were ordered to be lodged into the High Court for safekeeping in separate matters, not part of these criminal prosecutions. So I consider that if the statement of polls and the statement of recount were critical and we had to have the best evidence, that we would make an application to the High Court. So in 2021, when I came into the matter, we made an application to the High Court. Yes? And you recall in the meantime, one court somewhere, I think the Chief Magistrate, sometime around mid to about just after mid-year of 2021, made that determination of summary trial. But the prosecution still had to get these statement of polls. We had sufficient evidence to have launched these charges, but this was also critical. So we went to the High Court, and you would recall, I believe, Mr. Lowenfield objected. He was still with GECOM at that time, I believe. And he came to the High Court and he resisted our application, saying we were not entitled to it. Several things he argued. The Chief Justice, of course, granted our application, and we were given permission to copy all of the original statement of polls, and this was done under the watch of the Registrar of the High Court and several police officers. And so the process was done in a way that would preserve the integrity of the documents.
Of course.
And you would recall sometime, I believe, late 2021, when there were pictures in the public domain of a truck turning up at the magistrate's court to deliver these documents.
Yes.
Truckload.
Yes.
A truckload of boxes came. We had nearly 5,000 documents, and they had to be done for each and every defendant and the magistrates as well. This was in relation to the Chief Magistrate's Court, because remember, in the other magistrate, everything was in a sense on hold,
Yeah, same.
because they were waiting for the Court of Appeal to rule. So nothing was happening with those charges. On every occasion when I turned up, I asked the magistrate to please reconsider. Let's proceed. Let's move on. Please reconsider. You don't have to wait. But so with all this truckload of evidence came, and was disclosure was given to the defendants, and everybody who was before the chief magistrate signed. They received copies of it. And quite apart from this truckload of evidence, we also had video evidence. Video evidence from cell phones. Yes, you would have seen the number of videos circulating. So we had to go through those. Transcripts were made for most of them. These transcripts were provided to the court and the defendants, along with the copies of the video evidence. And we had a forensic analysis done of the statement of poll and a report done in relation to that. And all of this was done in late 2021, early 2022, when the prosecution delivered those documents and the video documents, videotapes. In early 2022, we were at readiness. Yes?
Early 2022.
Early 2022. Except that we felt that we had to press the courts to consider bringing all of these charges, which was before separate courts, together. Otherwise, we were going to waste the resources of the courts. We were going to overburden the system. We were going to put an unprecedented burden on the magistrate who was going to hear this matter. And so we felt that an application was necessary to the chief magistrate, and asked the chief magistrate, who has jurisdiction in law, to recall the matters from the other magistrates and place them before herself, or assign a particular magistrate who will sit and hear these matters, and perhaps sit and hear them continuously until we're done. You have seen the Commission of Inquiry inquire into the events of the March elections, and you've noted that it has lasted, am I wrong, more than 6 months, nearly 9? How long did it go for?
A few months.
Yes, quite at least 6 months. Well, a lot of months. And there wasn't that level of cross-examination that would take place in a criminal trial.
Right.
There was some, but not a lot. And you didn't have those many defense lawyers there on a daily basis. When these trials start, each and every one of our 90 witnesses, you've seen courtroom situations play out. There is going to be a testing of the evidence, which is expected. You expect people to test the evidence. But the court who's trying this matter will have to be an experienced court who will, I believe our magistrates, all of them who are hearing these matters or who heard these matters, are experienced magistrates, will have to be very sensitive and very ready to get on with it. Not have unnecessary applications made, or if they're made, listen to them, determine them in an expeditious manner, and let's move on. That's how one expects that all criminal trials will be dealt with by the courts. So, in March of 2022, when the prosecution was at that state of readiness, we made an application to the chief magistrate, and we addressed it to all the magistrates. We addressed it to all the magistrates. I have a copy of the letter here, you see.
Yes.
To the Chief Magistrate, to Magistrates Isaacs and Magistrate Daly. And we addressed all of them, and we explained that we intended to make the application in court, and was the nature of the application that we were making. These were the reasons why. It, as I said earlier, would be an alarming waste of resources for 3 separate courts to sit and hear these types of matters. And we indicated. And at the time we made that application, let me put something else in context.
Sure.
We also realized that that some of these defendants had not been charged for conspiracy. And so we asked the court to amend some of these charges to indicate the participation of all the persons who were before the court. And so that the defendants would not be prejudiced. They would understand clearly that we were saying that each and every one of them participated in overall conspiracy. They didn't need to know what the other one was doing. Mm-hmm. You can play a role in a conspiracy without knowing what each and every person is doing, but you know a general plan is afoot. And you know that others are acting and playing their little roles. Mm-hmm. And that's the theory of the prosecution case. So we sought an amendment before the chief in March of 2022 to amend some of the charges, 9 charges, to reflect that the particulars of the conspiracy embraced each and every one of the defendants who were before the courts. They weren't new charges. And the chief would eventually agree and grant those amendments. Mm-hmm. Yes? But there were 2 applications made in March of 2022. And one of those applications, as I said, was to consolidate all the matters, asking her to bring back the matters and send it to whoever. We didn't say to the chief that you must try the cases. We said you have the power and the jurisdiction to decide who could try it. And the second application was to amend. So we had 2. One, to consolidate, and 2, to amend in March of 2022. The chief said to us that she couldn't hear both applications together. She would hear one first. And when she had determined that one, she would then hear the second one. So she proceeded to hear the application to amend. Now, you may think that that took place in a day. No. It took us about 9 months. Well, March. It took us about 7 months to get to the determination of the application to amend. We had written submissions. Mm-hmm. We printed out the amendments. Everybody had them. The court had them at the time we made the applications. And that took 7 months to be determined by the court.
Why though?
There were adjournments granted in between. The chief had gone off on vacation, leave, on some of those adjourned dates. And so very early in the process of that application, both the defense and the prosecution had made their submissions.
Okay.
Let me put it that way. The court took about 7 months to determine that. Yes? And allowed the amendments, considered that the amendments were proper. And then we turned to the consolidation application. We saw, and we had pressed the court to hear both applications together because we saw that this was going to be protracting the process.
Yeah.
I've been in the courts for many years, and I have seen courts can sometimes deal with 5 applications simultaneously. One for amendment, one for avoiding costs, one for extending time, all of that. Courts routinely do this, routinely deal with several applications together. And I don't know what reason, what was the reason why the court didn't want to deal with 2 applications. Or I'll put it this way, no reason was expressed as to why we would hear one, go through this period of months, and then we would hear another one. But we were ready to argue them. So when we got to the consolidation application, There were several adjournments to January 2023, and then the Chief Magistrate retired. And on retiring, the matters came before Magistrate Isaac, who I believe acted briefly for a period, well, maybe still acting, I'm sure, as Chief Magistrate. And so now, apart from the two which were on appeal from Magistrate Daly, at one point in time, starting January of this year, all these matters ended up before Magistrate Isaac. And you would recall that Magistrate Isaac was still awaiting in relation to determining the mode of the trial, whether to try the matter summarily or PI. At that stage, when the other matters turned up before the Honorable Magistrate, I took the opportunity to remake my applications for the Magistrate Isaacs to try the matter summarily. And that took a little bit of submissions, but she then agreed. And so the matters were then determined, all 30 something of these charges now.
This is excluding the two that have gone.
Excluding the two, are now to be tried summarily. And then we raised the issue of the consolidation. Yes? It was, in my view, a mere formality, because we were now faced with a situation where no longer were the matters before separate magistrates. I'm not speaking of the two.
Yeah, right.
No longer did we have the bulk of charges between the chief and another magistrate. We didn't have that again.
Right.
They were all on the desk of one magistrate. So I thought that this would be a mere, oh, Your Honor, you will try these matters all together, I suppose. Yes, Mr. Ramdhani, let's move on. No, that became, I was then met with some of the defense lawyers arguing, but hold on, even those before the chief were not consolidated to be heard together. So that became a debate. It was later, I think some of the lawyers on the opposite side, the defense, they later conceded that the chief had very early into the day determined that those that were before her were going to be tried together. But that became a contentious issue before Magistrate Isaac when the overall bundle of matters were being sought to be heard together. So then the learned magistrate seemingly, I think, made statements that she was conflicted in some way with one or so of the defendants. And then decided around early part of this year to transfer these matters to Magistrate Daly. You recall we said we were ready last year when we made our applications. If our applications had been granted in March or let's say April, which would have been the kind of pace that we would have wished for, we would have been at trial around June, July, perhaps in September of last year. So now the matters were transferred before Magistrate Daly, and Magistrate Daly has all the matters before her. We are due to come back before that court on the 3rd of October. It's a sort of a case management to see where we are, and we at that stage will indicate that, look, we are ready, and I suppose every side will have an opportunity to raise what they want to raise, and the court itself may have to determine how to put aside days for the calendar. I must mention, there's a law in Guyana, the Summary Jurisdiction Magistrates Act. And Section 9 of that law gives, well, there are certain provisions in that law which speaks of the chief magistrate's powers. Remember I said earlier that the chief magistrate has the power to assign matters to other magistrates. And you see that happening on a daily basis. And the chief magistrate can assign matters and recall matters and so forth. The Chancellor of Guyana also has that power. And the Chancellor of Guyana also has a power to determine which matters can be tried by a magistrate. So there's an overall power residing in the Chancellor. I say that for to put context to what I'm about to say next.
Mm-hmm.
When these matters begin, when the trial of these matters begin, I don't, I would suggest it is not the kind of matters where we can have a trial date today and we adjourn it to next week or next month and have a trial date. You remember the COI, the Commission of Inquiry, was going on every day, and yet it lasted 6 months or months. We have 90 witnesses. We have a truckload of evidence.
And cross-examination.
And cross-examination, videotapes to be played in the courtroom, getting up, setting up the facility, rewinding and playing it back. When we start, this cannot be tried as a typical matter for many reasons. From a purely practical standpoint, there will have to be a dedicated focus by the system, the court, the prosecution, the defense, to be ready to deal with this. Yes? The process must be engaged. And we had made these submissions to the Chief Magistrate that a magistrate should be assigned to deal with these matters.
Yeah.
If it is Magistrate Daly, so be it. I'm not asking for a particular magistrate here. I'm saying that clearly. But it must be a court, we suggest, that is dedicated to this matter. In other words, it mustn't be adjourned at 11 o'clock because you have to deal with other matters. When we start, this is one suggestion. We don't have to do it every day of the week, but we could do 3 days,
Right.
full days, lead the evidence, present the evidence, come back next week, 3 days. So this perhaps is the approach. I can't tell the court how to do it, but I can make recommendations.
Yeah.
And I've done these recommendations before the Chief Magistrate. Yes?
So let me ask 2 questions as it relates to where we stand. And just to backtrack a little bit, you mentioned when this was moved from Magistrate Isaacs to Magistrate Daly, you said that there was some conflicting of interest, conflicting of issues. Can you explain really what that was about that caused the transfer?
Magistrate Isaac, and I want to be careful how I say this, Magistrate Isaac said that she could not try the matters. Yes? And that she would transfer the matters to Magistrate Daly. Wasn't very clear to me, but that was the end result, that she considered that she could not try the matters and that she would have to transfer them to another magistrate.
Understood.
Yes.
And you made some statements as well earlier in our conversation about the statements of Paul that are necessary for your evidence and for you to lead the prosecution. But these SOPs appear to be elusive.
No, we as I said, we have gotten certified copies of these statements of Paul from the High Court.
But from GECOM's perspective, when I think Mr. Lowenfield was there,
Yes.
these SOPs appear to be elusive in some way.
Well, I said that before we got to the High Court,
Yes, okay.
right? When we got to the High Court, we got them. Yes, there was a contested application in the High Court. We got them. And so what we are going to take to the court now are the certified copies of the statement of polls that were held by GECOM,
Yeah.
the ones that Mr. Lowenfield did not want us to have.
So, Mr. Ramdhani, these cases have been around for quite some time. Having an understanding of all of what has transpired from your personal capacity and being an experienced lawyer for decades, where do you see these cases going?
Well, going to trial. We have cases in court. These are charges. They must go to trial. We are in the process of... I have presented, I hope, without adjectival insertions, hopefully very neutrally, the events as they have taken place. you will hear what I have said, and you will make your determinations and possibly form your views. But I have told you, we turned up in court when we were ready, what we said, what we did, what we asked for, what happened.
Yeah.
And when we go in October to the court, we are also going to say that we are at the state of readiness, and we are hoping that the court will deal with any other preliminary issues that can arise very quickly, and so we can then set dates when we'll take the first witness. Yes,
So that's where we stand.
that's where we stand. I know I can only sit here and speak as a prosecutor. I don't wish to get into any other aspect of this discussion. And so I'm trying to stay within the confines. Remember, this matter is still before the court. I all I have done, these matters are being heard in a public court. So all the things I've said, if you were coming with me on a daily basis as a news reporter, you would have been able to see all of what I said take place. So I believe it is quite in order to explain and to say generally what is going on.
Yeah.
That's where we are.
Mr. Ramdhani, I want to thank you so much for taking the time today. If there are any concluding remarks that you'd want to make at this time on this matter,
Yes.
you can go ahead.
I can only say this, that the prosecution has a ton of evidence to lead. We have the statement of polls, the certified copies. We have the videotapes. We have the witnesses on ready. And we know the courts have been trying their best to deal with these matters as judicially as possible. The matters are now currently before Magistrate Daly, and we're hoping to get on with it. Yes, and hopefully bring this saga to an end,
Indeed.
one way or the other. Yes.
One way or the other. Mr. Ramdhani, thank you once again so much. You've heard from Mr. Darshan Ramdhani K.C, Special Prosecutor, and we've spoken extensively on a lot of the election-related cases happening here in Ghana. My name is Shaquan Gill, and I'm saying goodbye for now.